We're delighted and lucky to have Philip Dykes, chairman of the Hong Kong Bar Association, to talk to us. Philip came to Hong Kong in 1985. He thought it would be for a few years and joined the Attorney General's chambers. He left government service in 91. He took silk in 1997. And by the way, I had to research this expression, and beside finding that it just meant becoming Queen's Counsel, the first comment I found on Wikipedia about silks is the following: a QC status means they generally charge higher fees than ordinary barristers and always have another barrister as an assistant. But Mr. Dykes told me that was not the case because he's doing constitutional work and yeah, anyway, more importantly, Mr. Dykes has also served in the Hong Kong Bar Council for a long time. He was vice chairman between 1999 and 2004 and chairman in 2005 and 2006. He was elected chairman for the third time in January 2018 in a hotly contested election that we have all heard about. And this was the main reason we wanted to invite Mr. Dykes to join us. Today, he's going to talk about the rule of law in Hong Kong, which is probably the most significant difference between Hong Kong and mainland China. All reporters who have followed political life in Hong Kong over the last few years, including numerous trials of activists, the interpretation from Beijing, and judicial reviews, have had to deal a lot with the court's decisions and procedures, which is a sign of how politics are closely related here to the rule of law. This makes your talk to us today all the more relevant. Please welcome Mr. Phil Dykes. Thank you.
The title of my talk, No Preferred Outcomes, is taken from an answer given by Associate Supreme Court Justice Samuel Alito during his confirmation hearing in January 2006. He was explaining to the Senate the main functions of a judge. It was, he said, to make decisions according to law because the rule of law demanded it, even though it might be easy to make a pragmatic decision, and that decision might command popular support. He said, and I quote his words, "When I became a judge, I stopped being a practicing attorney, and that was the big change in role. The role of a practicing attorney is to achieve a desirable result for the client in the particular case at hand. But a judge can't think that way. A judge can't have any agenda. A judge can't have any preferred outcome in any particular case. And a judge certainly doesn't have a client. The judge's only obligation, and it's a solemn obligation, is through the rule of law. And what that means is that in every single case, the judge has to do what the law requires." I'm not going to talk today about the need for judges to make difficult decisions. I believe that Hong Kong judges can and do and will continue to make difficult decisions and can be relied on to uphold the rule of law for the years to come. Rather, I want to emphasize the need for other decision makers in government, the administrators and the lawmakers, of the importance of not looking to secure the preferred outcome at any price, but to be guided by the rule of law and realize that there are no preferred outcomes for judges and they should not be pressured into making decisions one way or the other. I want to make the point at the outset, though, that because of the inheritance of a common law system, even through the means of a deeply unfashionable colonial rule for 150 years, and because of this material prosperity, the rule of law should prosper in Hong Kong and mark out the region from neighboring countries. There may be challenges to the rule of law to come, but Hong Kong's history, its tradition, means that decisions avoiding the preferred outcome should be second nature to our judges, and that our lawmakers and administrators, knowing that history and tradition, should appreciate that that is the case. They must not carp or criticize judges for court judgments they do not like because the result is not what they wanted. The need to appreciate the rule of law extends to decision makers outside Hong Kong who can make decisions affecting life in Hong Kong. I'm speaking, of course, of the Standing Committee of the National People's Congress, which may be in a position to secure a preferred outcome to any problem arising in Hong Kong under the Basic Law, because the rule of law constraints in the mainland are weaker. But before I get ahead of myself, I first need to say what is meant by the rule of law, or more accurately, what I think it means. The first thing to say is that the rule of law is an elusive, ideal principle. I say it's an ideal principle because nobody in their right minds would wish to live in a society that wasn't governed by some rules, kind of legal rules, even if they were applied arbitrarily and without due process. Imagine, if you can, a community where unconstrained self-interest prevailed over every other social value and where life was precarious in the extreme, because the strong and the selfish prevailed always over the meek and the weak. In the words of the 17th century political scientist Thomas Hobbes, who described in his book Leviathan, a society without settled government and legal rules as in a state of war, and in the mid-17th century there were no Geneva Conventions. He said it was a society with no arts, no letters, no society, and which is worst of all, continual fear and danger of violent death, and the life of man solitary, poor, nasty, brutish, and short. I say that it's an elusive ideal because there are perhaps as many definitions of the rule of law as there are people in this room. For some people, the rule of law means living in a society where there are rules drawn up by government which are then applied strictly, remorselessly even, by an impartial judiciary to its citizens in an even-handed way, inasmuch as high or low in society, you're all treated with an unremitting legal exactitude. This is something like the legalist tradition that was current in ancient China 2,500 years ago, which is based on the belief that people who are naturally inclined to commit crimes are less constrained from doing so by fierce laws and a strong police force that was sure to find out wrongdoers. The harsh punishments inflicted by legalists, death usually, horrible mutilations sometimes, were thought necessary by solicitous gentlemen philosophers to protect individuals from themselves, who were their own worst enemies. As one legal text from the time says, to prevent wrongdoing and stop transgressions, nothing is better than making punishments heavy. When punishments are heavy and criminals are inevitably captured, then the people dare not try to break the law. Hence, there are no penalized people in the state. When there are no penalized people in the state, it is said then, quote, clear punishments eliminate executions. Moving on a bit, some 2,000 years, we have a less frightening concept of the rule of law that still has its supporters, and which puts its trust in parliamentary democracy and fair play. The English jurist A.V. Dykes wrote in a book about the famously unwritten British Constitution in 1885. He was one of the first jurists to use the phrase the rule of law. He said, the rule of law means, in the first place, the absolute supremacy or predominance of regular law as opposed to the influence of arbitrary power. and excludes the existence of arbitrance, of prerogative, or even over wide discretionary authority on the part of the government. It means, again, equality before the law, or the equal subjection of all classes to the ordinary laws of the land administered by the ordinary courts. And lastly, that in short, the principle of private law have withers been by the action of the courts and parliament so extended to determine the position of the crown and of its servants, thus the constitution is the result of ordinary law of the land. Dykes put a great deal of faith in the common law as interpreted and applied by upright judges. But his rule of law theory depends on Parliament making laws that are just. That's the weakness of his model. Under that model of Westminster government, laws enacted by Parliament are the supreme source of law. And who controls the legislative branch in this model? Is, of course, the executive that holds the majority of votes in Parliament. There's nothing to stop Parliament making unreasonable or unjust laws. They frequently do, often as a result of short-term political pressure. And I bring to mind my own recollection in the 1970s, a raft of legislation directed against the political problems in Northern Ireland, which came home to roost in the European Court of Human Rights 10 years later. An 18th century jurist, William Blackstone, described the unlimited parliamentary lawmaking power in 1765 as such. It can change and create afresh even the constitution of the kingdom and the parliaments themselves, as was done by the Act of Union, and the several statutes for triennial and septennial elections. It can, in short, do anything that is not naturally impossible, and therefore some have not scrupled to call it power by figurative the omnipotence of Parliament. True it is that what Parliament doth, no authority upon earth can undo. Now, if you cannot trust a legislative assembly to enact just laws, you can at least make it difficult for them to do so. This is where written constitutional documents are important to the rule of law. Constitutions come to existence when the government wants to place checks on otherwise potentially unlimited executive and lawmaking powers. The most famous written constitution, of course, is the US Constitution, which is still going strong. Typically, a constitution attempts to delineate areas of government and powers, legislative, judicial, and executive, and sets out the rights of citizens and their relationship with the government. The Constitution is the supreme law, and the common law and man-made laws come under it. Judges interpret laws by reference to the Constitution and have the power to declare laws or executive acts unconstitutional. If the government of the day really wants to push through a measure which is not consistent with the Constitution, then it must change it by constitutional means, which usually means voting by a supermajority, say 75% of members in the legislature or the constitutional body, or even a referendum. But having an elegantly drawn constitution is of little use if the men and women who work within it ignore its provisions or are cowed by another branch of government, usually the executive. An example, which may be known to many journalists here, is quite recent, of a government ignoring court orders occurred last month when the Kenyan court ordered the suspension of a government order banning several TV stations which had screened a political event by the opposition. A spokesperson for the Committee to Protect Journalists described the situation in this way. The Kenyan government's refusal to abide by the court order and permit 4 television outlets back on air is not only contempt for the rule of law, but a brazen example of censorship, said Angela Quintal, CBJ's Africa Program Coordinator. Every day these TV stations are kept off the air and their journalists are harassed or intimidated, further erodes Kenya's position as a leader of press freedom in Africa. The rule of law therefore requires something more than just legal structure, written or unwritten, that segregates the legislative, judicial, and executive branch of government. It requires a willingness to make that structure work and avoid interference when it seemed to be working well. Whether that willingness exists can be seen by looking for evidence that the system works and delivers results for ordinary people, and not by studying legal texts or theories of government or the works of jurists. I therefore commend to you the World Justice Project definition of the rule of law and its methodology for assessing whether the rule of law delivers in particular countries. The World Justice Project definition avoids complicated legal philosophical definitions of the rule of law and instead looks to countries' adherence to the rule of law from the perspective of ordinary individuals and their experiences with the rule of law. The definition of the law is simple. It has four basic elements. First of all, accountability. The government, as well as private individuals, are accountable under the law. Secondly, just laws. Laws are clear, publicized, stable, and just. They include laws that protect fundamental rights such as scrutiny, security of persons and property, and some core human rights. Thirdly, open government, process by which laws are made, administered, and enforced are accessible, they are fair and efficient. Fourthly, accessible and impartial dispute resolution. Justice is delivered without undue delay by competent, ethical, independent persons who have access to adequate resources and reflect the makeup of the community they serve. The criteria used to see whether these principles exist are, as I said, outcome-oriented. Because of this, they allow for comparisons to be made between societies governed by totally different legal systems. For instance, one factor affecting whether or not a country has accessible and impartial dispute resolution mechanism is whether civil justice is delivered efficiently. The criteria used for measuring this are: people can access and afford ordinary civil justice is free of discrimination, civil justice is free of corruption, civil justice is free of improper government influence, civil justice is not subject to unreasonable delay, civil justice is effectively enforced, and alternative dispute resolution or mechanisms are accessible, impartial, and effective. Hong Kong scores extremely high in this area. Court fees in Hong Kong are not prohibitively expensive, and there's a reasonably comprehensive legal aid system. Courts do not differentiate between people and companies because of national origin. No reports of corruption of judges who are paid extremely well, nor do judges act as government direction to favour one party over another. There's some delay in the courts, but not excessively so. If a judgment is obtained in the court and it is not a paper judgment, Hong Kong courts have the means to enforce awards and make litigants pay up. Finally, there are many alternatives to courts if parties do not want the expense of court proceedings. Hong Kong is particularly proud of its arbitration and mediation network, which are effective and free from corruption. I do not have the time to go through all the other factors which are used to measure the four main components in the World Justice WJP definition of the rule of law, but they are absence of corruption, criminal justice system, enforcement of government regulations, order and security, recognition and protection of fundamental rights, and accountability. The WJP ranks countries for rule of law status after analysing data about these factors provided by in-country respondents who are named in the report. The contributors are largely legal practitioners and academics, as the case is with most countries. The most recent rankings were published in January 2018. Hong Kong did not come at top of the list of 113 countries and territories reviewed. That accolade went to Denmark. Nor was it bottom. The rule of law wooden spoon went to Venezuela. Hong Kong came in at a creditable number 16. It was sandwiched between Belgium at 15 and the Czech Republic at 17. It ranked above the USA, 19, and China, 75. In the East Asia and Pacific region, only New Zealand, Australia, Singapore, and Japan had better scores. The higher the income of the country, the higher its rankings. there's almost an exact correlation between global placings and income in the first 20 countries listed in the main index. The rankings seem to reflect reality too. Who will be surprised at the Philippines dropping 18 places from 70th to 88th under the watch of the current President Duterte? The puzzle for others is that in spite of Hong Kong's excellent ranking, something that has been achieved in previous years too, why the current worry about the rule of law in Hong Kong? Things, you have to look at the list, could be much, much worse. The fact is that the greatest threat to the rule of law in Hong Kong lies in the fact that Article 158 of the Basic Law, allowing for decisions, interpretation decisions by the SCMPC, is made by a non-judicial body that's not accountable under Hong Kong law to anyone here, where its decisions have effect. The SCMPC is able to choose the preferred outcome because it's not a judicial body. Courts and government in Hong Kong are then obliged to give effect to these decisions as a matter of Hong Kong constitutional law. There's nothing new in this observation. The power of SCMPC interpretation had been seen as problematic for over 25 years, soon after the Basic Law was promulgated in 1991. Its potential to trump independent judicial power was made abundantly clear with the 1999 interpretation concerning the right of abode cases. Subsequent interpretations were not as eye-catching as they dealt with rather dry and technical matters, such as how a new chief executive's term was to be calculated if a predecessor did not complete his term, or whether a doctrine of legal state immunity in commercial contracts was absolute or limited. These decisions did not affect and were of no interest to the man in the street. However, the interpretation in October 2016 about the electoral oath taking seemed to intrude into an area where the courts were well equipped to make a final determination without the assistance of the big guns from the Standing Committee of the National Reviews Congress. The interpretation was, in my view, a way of securing a preferred outcome with no risk of a possible embarrassing divergence of views from a judge. The real risk to Hong Kong now is that individuals and bodies will make clear their preferred outcome in legal matters involving the Basic Law, in the confident expectation that the Standing Committee would chime in with a convenient interpretation that accords with that preference. I will concede, note this is a concession that's made only for argument's sake, that for a would-be legislator to talk of pressing for independence in Hong Kong is totally incompatible with the Basic Law. I will go further, and again, for argument's sake only, and say that the talk of self-determination in Hong Kong under the Basic Law could be a step too far and equally disqualify a person from standing. Those are positions that can be taken forensically. However, I would not expect that a mainland official closely associated with the implementation of the Basic Law to say, authoritatively, that either statement is definitely constitutionally out of bounds. That is a matter which is initially for our courts. And if there has to be an interpretation of the Basic Law at the end of the courtroom proceedings, then the Standing Committee will have to deal with it in due course. But nothing shall be done or said until then, suggesting that there is or may be an official preferred outcome to this problem. That is a worry I have about the rule of law in Hong Kong. Official expressions of preferred outcomes of major constitutional issues have a corrosive effect if they are viewed as preempting judicial determinations. Some might say that they are calculating, in fact, to sap the morale of judges. I don't say that so meant, but the fact is that they may appear to others to have that effect. That is damaging to the rule of law because this is an area where perceptions matter. as is clear from the international attention that's been paid to Hong Kong and rule of law issues in the past 12 months or so. I conclude by saying that I'm confident again that our judges will abide by Justice Alito's principle of not letting preferred outcomes deflect them from doing their supremely important jobs. Long may that continue. I thank you for your attention.
Thank you very much, Mr. Dykes. So we'll take questions, and I'd like to give questions to journalists first. And while there's a pen there, but before that, I'd like to ask you if you could quickly revisit for us the episode where you took the challenge at the Hong Kong Bar Association. Why did you decide to do that?
I see a topic completely unrelated to my speech, but never mind. I was pressed to stand as chairman of the bar again in, I think, second or third week in December. I've been told that several senior members of the bar, including past chairman, had decided that there should be an election this year. I was told that a number of people have been selected who were willing to take part in the contest, and that I was the last piece of the jigsaw, and I had exactly 24 hours to make up my mind before nominations closed. At the time that was communicated to me, I was 5,000 miles away from Hong Kong, and I had my mind on completely different things. But I resolved that I would do this, and as I say, the rest is history.
Thank you. Ben Bland.
Thanks. Ben Bland from the Financial Times. It seems that Beijing wants Hong Kong to move to a situation where democratic rights, political rights are heavily circumscribed, but they obviously want to maintain confidence of business in the legal system in Hong Kong at the same time, somewhat like the Singapore model, if you like, where businesses are happy to do deals, sue each other, but no one would argue that Singaporeans have the same kind of expectation of political rights as a conventional democracy. So my question is, do you think it's sustainable for Beijing to move toward that model here where democratic rights, rule of law as it pertains to those rights is heavily circumscribed, but business can still maintain confidence when it comes to the rule of law in commercial settings?
Thank you, Matt. Those are two preferred outcomes. One going one way, one going the other. But ultimately, you can't have one without the other. It may take many years for that to dawn on governments, but you can't hold yourself out as being a system that ascribes to the rule of law, and we're particularly good at dealing with commercial and arbitration matters, but not also accept the burdens that go with that, which are dealing with the nitty-gritty of political problems, protests, freedom of expression. And you will be found out. As I say, it may not be this year or next year, but it's unsustainable.
Next question. Over there. If you want to raise your hand in advance, then I can move the mic to you. Thank you.
Hello.
Please introduce yourself as
Mr.
well,
Dykes,
sir.
thank you very much for your enlightening talk. I'm Mark Pinkston, a freelance journalist. I refer to a recent case of 3 young activists who had appeared in court on charges of relating to rights. Has taken 8 judges, High Court judges and a magistrate, to give various degrees of sentencing. One was a community service, another one was a jail term, and finally the Court of Final Appeal quashed all of the sentencing. This caused quite a bit of public outcry. A panel of 12 jurors actually wrote an open letter decrying the decision of the Court of Appeal, and said that the Hong Kong judiciary had been interfered with. Would you say that there's such a varying degree of sentences, going from community service to prison term and to quash sentence, would this be the difference would be a preferred sentencing?
I'm familiar with the case. I represented one of the defendants in the Court of Final Appeal. They, in fact, all three of them were sentenced to community service orders, which were all converted into prison terms. I think that's right. Perhaps one of them was given a short prison sentence, but they ended up with substantial prison terms in the final analysis. It's quite clear from my reading of the papers that the magistrate in the case addressed the right questions, she addressed the right law, the correct sentencing principles. The Court of Appeal took a different view from that. It explained why it took that view. One of the judges explained his view in slightly colourful language, which the Court of Final Appeals really said they had no need to express himself in that way. But they took a different view. The Court of Final Appeal reviewed the matter, decided the matter according to legal principles, the correct legal principles, and quashed the decision of the Court of Appeal. Throughout it all, correct legal principles are applied to the problem at each stage, inasmuch as the magistrate dealt with the matter according to law as she thought there was to be. The Court of Appeal thought, according to legal principle, they could vary the sentences. The Court of Final Appeal said that legal principle was erroneous. It was all, the whole of the proceedings were played out within the framework of the rule of law. I'm not saying that the judges at any stage were politically motivated to achieve a preferred outcome. The outcome that resulted was the outcome dictated by the rule of law.
Yes.
Wei Du, Channel News Asia. I have two questions. One is there is a proposal in Macau to amend the basic law to say that only judges of Chinese nationality will be allowed to sit on cases of national security, regarding national security. Are you concerned that that's something that could happen to Hong Kong as well? And also, in a lot of countries, even on a bench, there's a wide range of political opinions. In the US, judges are nominated sometimes by political parties precisely for that reason. Where do you think, in a political spectrum, does the Hong Kong bench fall? And do you think that's a discussion that needs to be had to maybe for people to have a better understanding of the judges' political leanings?
Two questions there, and I've forgotten the first one.
The
Macau foreign judge. I find that very difficult, because if you read the basic law, you'll find that issues of foreign affairs and defence are reserved. They're not the province of judges. But under our system, these judges will decide whether or not a matter falls in that category. Foreign judges are part of the landscape of the basic law, along with foreign lawyers. So the drafters of the basic law must have contemplated that national security issues might come before judges who do not have the Chinese nationality. So there is no case, in my view, for seeking an amendment to the basic law, for depriving those judges of the opportunity to sit in such cases, because that will be incompatible with the basic law. You would have to amend the basic law to say foreign judges can't sit in cases like this. So that's my answer. I don't know what they do in Macau, but that's the answer according to the basic law. As for the political complexity of judges, well, there are an awful lot of them. They come from very, very backgrounds. It's impossible to make a generalization about their political views, and as Samuel Alito said, their political views, which may point towards a preferred outcome, are irrelevant in such matters. It's doubtless that the political community might push a judge one way rather than another, but ultimately a judge cannot allow, must not allow his political views to influence or determine the decision that he has to make.
Next question. Well, if no one among us. Incredible. That doesn't happen often. Cliff has one. I would have one as well. Thank you. Go ahead, Cliff.
When you were you and your associates were elected to the Bar Council, some people said that this would mark a change in the bar's strategy. There were even suggestions that it would become more akin to some sort of advocacy group or political party. The lines between legal issues and political issues these days seem to become increasingly blurred. How will you make sure that the Bar Association maintains its reputation for integrity, staying out of politics, and commenting only on the law?
It's the case, sorry. No. Right. It's the case that some cases get to court precisely because they're political, such as whether or not a person can stand for election, or whether or not an election result might be challenged. There is a political dimension to all these cases. It's important that the Bar Association, when they perceive to be a real issue that is worthy of comment, and I emphasize that the Bar Council does not comment on matters, every matter that arises. If it sees it as a genuine issue, whether that be a matter of constitutional law or a matter of legal principle, it will make it clear in the way it articulates its response that it is concerned with a legal issue and not a political issue. Some people seem to willfully ignore the distinction. I can't help that. But you read them carefully, the angle that the Bar Council will take every time is on the legal issue underlying what may be seen to be a political issue.
Thank you. We have a question there. Laura?
Hi there, Laura from AFP. We're talking about the functioning of the court system, but the one I wanted to talk about was the decision by the MPC to allow mainland security at the West Kowloon station, which kind of bypassed any legal processes. Are you concerned that the rule of law and the judiciary might just be battered to one side to kind of steamroller through these kind of decisions in the future?
Those are the kind of decisions that I'm concerned with, and the previous Bar Council made a fairly strong statement about its position on that, and I see no reason to modify or dilute that statement. It's still a matter of concern. As I say, it's a decision which is made by a body that profoundly affects people in Hong Kong. That body is not accountable to people in Hong Kong, and that's the rule of law issue. Because the idea should be that when you make such a decision, whether it's made by the executive or the legislative or the judicial branch, you should be able to comment on it and bring people to account if it's necessary. But that's exactly the issue that I've been seeking to address in my talk.
Thank you. Doug?
Mr. Dykes, you served on as head of the Bar Council before. I'm just wondering what the main difference between your current term and your previous term it has been. What do you see? What did you think was the main challenge when you did it before, and what do you see it as now?
I served, I think it was 11 or 12 years ago. Happy times. There were no interpretations then, and I think on that time, I think I might have dealt with the rather dry and academic subject of when does the chief executive's interrupted term, what's the status, does a new chief executive start a new term or continue with the previous term? That was about it. And issues then were largely routine, no major constitutional issues. This time round, as I say, we foresee more constitutional issues, and certainly as far as the bar is concerned, there are more livelihood issues. When I was elected, I went round many chambers and listened to younger barristers, and they were concerned about the future of the bar, their future, their profession, of making a living. And that's something that I've undertaken to address in the term of my chairmanship. But happy days 12 or 13 years ago, but it's not to be the case this time.
May I then take the last question and ask you if you anticipate more interpretations?
They seem to be coming thick and fast. I would not rule out a further interpretation if the issue that I alluded to about independence and self-determination, one can easily foresee that bubbling up to become a legal issue in the courts, and that being subject to an interpretation by the SCMPC.
Is this a general concern? Is this a concern that you all share?
It's my concern, and it's a concern of many of the people on the Bar Council. I think many barristers.
Well, thank you very much. It's 2 p.m., so please join me in a round of applause for Mr. Dykes and his very interesting talk.